Welcome sir for today's webinar. To all the participants, we welcome our speaker for today's webinar, Mr. JLN Murthy sir. JLN Murthy sir is our patron at Legal Intelligence, an international arbitrator and a lawyer from Hyderabad, and he specializes in international law. Sir is a graduate of law from Osmania University and Nalsar Law University and has served as vice chair of the American Bar Association, practicing on the corporate side and conducted corporate training to 42 companies on arbitration, mediation, and conciliation, intellectual property rights, cyber laws, taxation, criminal laws, contracts and agreements, commercial laws, employment laws, labor laws, competition laws, etc. Sir has given training in IPR in more than 85 corporate firms and companies. With his experience in the field of IPR, will help all of us to gain informative session from today's webinar. It is with Sir's insights only that we are able to host today's webinar. Hope all have an informative session. Over to you, sir. Thank you.
Thank you. Thank you very much for a wonderful introduction. I'm proud to be associated with Legal Intelligence Organization. Friends, this organization is mostly with the students who are interested to enhance their knowledge on the legal side, very specifically for the modern requirements where I feel myself sometimes in the knowledge side, we need to share with everybody in this world. That means you need to grow yourself and you need to understand the nitty-gritties before you end up with completing your graduation. At the same time, you also need some time to educate yourself in such a way that what is your final choice, what is the area of the practice, where you want to go. Because when I have studied the law, it was only a litigation system. That means I used to take the docket to the court and from court again take a date and come back. This is early 90s. But today the avenues are changed. Multiple avenues have come in place. But fortunately or unfortunately, I have joined in the corporate world. I worked for 20 years in the corporate side for the global companies and traveled around 82 countries. My last stint was with Red Bull. Everybody may be knowing that is an IPR related company. And at the same time, it's a global company, branded, world branded company. And at the same time, we all are practiced during the course of the corporate world. We have learned many things on the legal side, not only the litigation, there are multiple areas which I'm proud that I thought sometime that I need to whatever the knowledge I gained should be shared with all the people. That means the young budding people, those who are coming up, because I also had an institution called ICADR, the Arbitration Institute at Hyderabad Regional Center. And my corporate side practice, other than this, I'm an independent director in few corporate multinational companies, not only in India, in the other countries also. This has made me more strengthened and also gaining the knowledge from the practice side or the work side. I am there, and this really made me to grow myself and also share my knowledge. So thanks for giving an opportunity by Legal Intelligence today. And at the same time, I also thank all the delegates who have participated today in this webinar. Initially, I thought that I should first make you all understand that what is intellectual property. That means an introduction level where we all need to enhance our knowledge, and at the same time, yeah, at the same time, first we will be discussing about the IPR related matters. Very specifically, initially the contents will be on IPR introduction, IP offices in India, types of intellectual property, nature of intellectual property, patents, its definitions, copyrights and trademarks and trade secrets. What is the trade secrets? And it is confidential information, geographical indications, concepts of semiconductor, need for the sui juris, and also the treaties behind this particular thing. Friends, you may be all knowing many things. You may be knowing a trademark, you may be knowing a brand name, you may be knowing multiple things in your life. In day to day, yeah.
Gunu gunu. Gunu kora gunu kora. Venkatasha Venkatasha gunu kora. Gunu do. Nana gunu do gunu do. Nana gunu do gunu do. No no gunu do. Gunu do. Gunu do.
Okay. Okay. Can everyone mute please? All of you please mute. Okay. Now in day-to-day life, you may be going across with multiple things. You may be having a cool drink named by Coca-Cola. You may be having a laptop. In that, you may be using a Microsoft Word or Microsoft Excel. So all these things are related with a brand. That means a value has been created by the intellectual property rights. You may be initially knowing our Microsoft owner, Bill Gates. If Bill Gates doesn't have the Microsoft with him, do you think that anybody will recognize him? No. That means the value he has created for his brand name of the Microsoft is worth billions of dollars today. That means when he started his company, Microsoft, then he may be a smaller amount, he could have started it. But going further in the days and also in the software and other areas where he was existing in the business side, he has created a big value, money for his brand. Today he shifted his brand name from his company to Microsoft to another small name. Why? Because without brand he cannot exist. That means the value he has created for his brand name is really worth billions of dollars. And it gives a revenues for him to have day-to-day life and also to donate many of the people. All these things is doing with brand name of Microsoft. Similarly, you can say Coca-Cola. Coca-Cola is a brand created. Pepsi is a brand created. Red Bull, which has been created four decades back. So all these things are brand creations. Without brand, they cannot exist. Without brand, if a Coca-Cola bottle drink has been sold, nobody will purchase. Similarly, if you take in India, the people, those who are having the cool drink, Maza or some other thing, Limca, without brand, nobody will purchase that cool drink. So similar way, this is how the brand creation happens. And what are the peculiarities, what we need to take care, that is why what is as per law we are going to discuss today in this particular schedule. That means, what is intellectual property rights? It is an original creation of a human intellectual, such as artistic, literary, and technical or scientific creation of an intellectual property rights. Refers to the legal rights given by the inventor or creator to protect their inventions or creation for a certain period for the time of the time. That means a creation which he has made, which is not similar to some other product available in the market, either an FMCG product or XYZ product. When you look across these things, there is a differentiation between one particular product to the other product. That means a artistic or a scientific or a technical creation which is not similar, then it will come under the intellectual property. Then he owns the rights on that. By the owning a rights on that, he will get revenue by giving royalty agreements. All these things are multiple avenues for anybody who owns this kind of an intellectual property. That means the legal rights confer an exclusivity right for the inventor or the created. creator who fully utilizes the invention or creation for a given period of time. Just think of a human creation has been happened, and that human creation is a owner, and which will be kept in a bank locker. He is the owner for that. He is keeping the intellectual property into his own rights and keep it in a bank. He gets either a revenue, he gets in a, when he keeps in a locker, he gets his own royalty also. So all these things are very vital, which is in the modern economy. So need to understand the what is now. Furthermore, what is a trademark, what is a patent, and what is a copyright, what is a design, all these things, what is infringement, all these things comes under intellectual property. Maybe some of you are the lawyers in this, most of them may be lawyers, some of them who are very specifically in this field are a scientist, very specifically who has done the engineering, who has done the science, BSc, commerce, or any field you take, they are involved in intellectual property work. That means sitting at home, we can do the intellectual property work. A software company comes to me and asks that, please prepare this particular software which we have made. This is a unique one where nobody has this kind of a software with them. I want to own this particular software, and I want to tomorrow. Similar thing what Microsoft does today. So he owns that particular software, asked me to make the patent out of that particular software, and he is the owner for that. That means for the next 10 years, he is the owner, and whoever uses it, it is an infringement. Just think of how the legalities are also involved in this. That means an established who has intellectual property and which is related to innovation of a product is called a intellectual property. At the same time, what exactly is intellectual? A product which comes out of an intellectual ability to think and understand and understand. I'm unmuted now. Okay. He creates with his ideas and with his intellectual property, he creates of his own the intellectual, what it comes out of his brain. He creates a own image, he creates a product of his himself. That means an IPR is a strong tool to protect investments, time, money, effort invested by the inventor creator of an IP. Since it's a grant, the inventor creator an exclusive rights for certain period of time for use of the invention and creation. That means this is how the intellectual evolves, that intellectual evolves into, and where he presents, reviews the, furnishes the IPR with special emphasis of various related agreements and treaties such as WIPO and TRIPS, which will form under this particular IPR creation, and various organizations and treaties are made in this particular brand creation or a patent creation where the international organizations are developed. You could have heard WIPO, you could have heard USPTO, you could have heard Hague systems, you could have heard many more
Some technical issues are being occurring. Sir will be with us very soon. Thank you for the patience. Due to some technical Due to some technical issues, sir will be joining us very soon. Thanks for your patience. The participants are requested not to draw anything on the PPT. The participants are requested not to draw anything on the PPT. Thank you.
We form under the intellectual property rights. It means that what are the various forms which come under the purview for the intellectual property rights. That means a patent, a trademark, a design, which are referred and which are considered as an IP property rights that helps the person to protect the inventions and a creation. So when we create a particular X product or a Y product, when it has some kind of a existence in the world, that means somebody wants to grab that particular thing, then he tries to make use of that particular thing, then it is called as a infringement. Let us first discuss about the patents, which is very, very important, and where you will find the trademarks, service marks, and commercial names are designated. All this protection against the unfair competition and rights resulting from intellectual property that is made out of industrial, scientific, and artistic fields. IP is bundle of legal rights resulting from intellectual creativity, where you find the intellectual property includes the right relating to the various discoveries and also the legal rights governing and use of creation of human mind, at the same time protected under various related laws. That means the laws which are there, you have a very heavy competition when some creation has been made. That means a next creation has been made, or a brand or a trademark or a patent is been created. You will find by the time you discover that and tell to the market that I have created this, by the time the infringement happens, that means some other body, some other person, when you are doing some kind of a Google browse or some kind of a work you are doing, he will be able to grab that somebody is doing a scientific work on this, and he will try to take and put it on his own, under his hand, that I have created. By the time you go to the application with a patent or a copyright or a trademark, some other person always there in front of you in a gate. That means in a government organization where the registrations and other kinds of things are happen, and where you will find that by the time you reach there, somebody is also started claiming on that. This is what an IPR. Very specifically in Indian side, you may be finding 4 to 5 different avenue. Very important is 4 to 5 different offices. Very specifically, when you have the office of controller in general, which is based at New Delhi, and for the designing wing you have an office at Calcutta, and whereas the patent you have in Mumbai, Calcutta, Delhi and Chennai, whereas for the trademark registry you have in all cities, major cities, that is metro cities, Calcutta, Delhi, Mumbai, Ahmedabad and Chennai. At the same time, if you are looking at the geographical indications, the registry you have only at Chennai, and the patent information service you have at Nagpur. That means this particular usage of various intellectual property things, we have various offices in India. Other than this, you have the international organizations who support you in this particular registrations. You may be heard the USPTO, you could have heard the USPTO and WIPO, WIPO, various organizations are there. And whereas for the designing part, you have WIPO at Hague. That means at the Hague, you have only the designing registration. So all these things for the international, where you need not go to country and get your trademark or patent or a copyright to get registered. At one go, you can do these particular registrations by an application, single applications. So the organization which the country which has signed this particular signatory of the conventions, they will be able to access to other countries also and get registered from, for example, from Delhi. If you do it something, then automatically the Delhi office people, government office people will go around and get this particular registration of patent or XYZ where you are looking at for registration in the worldwide. That the similar things, like you could have heard the Madrid protocol. This Madrid protocol is one of the important protocols where the recent past all the countries have signed. That means you need not, every country will adopt that particular protocol and he will be the signatory. That means when he does that particular signature, that he is accepting. If, for example, in Africa, if you file an application of a patent, you want to go after Africa registration, you want to go global, then the African country people where you have approached under the Madrid protocol, he will get registered in all the countries, and whenever there is a challenge on that, he will bring it to your notice also. That means the registration can be happened in the worldwide at one go. I have told you about the Hague system on the geographical one. So all these things are developing in the recent past, and people, the intellectual people who have been making this through their human interface, they are creating this kind of things, who are the owners can own and keep it and deposit like a money in his bank account. So these are the very important one, and let us go forward and discuss about the patents. Patent is an exclusive right granted by government if the application is disclosed as a new invention. If a patent application has been filed, you will be the owner. After 1 year, you'll be the owner, or within 10 years. For the 10 years. That means if you create something as a patent, and where you, by the time you get registered, and when the registration is on your name, that you will be owner for that for minimum of 10 years. Further, you need to renew it. But when you create something, some software or some pharma or some kind of a new invention when you made, by the time if it is in the market, almost parallel to that, some other also will be invented. That means with a slight difference, either in the patent or a copyright or a trademark, somebody else will come out. He will try to grab your own money you have created through the human, the intellectual property. That is what I was telling initially. Microsoft earlier, when Bill Gates has created Microsoft company, he could have not thought that the Microsoft will become so big company, such a big company in the world. Without Microsoft name, Bill Gates is not there. Now, the big multinational companies are also creating a separate small companies where they will have their patents, trademarks, and copyrights in that particular company name. Why? Because they want to keep it in their own bank account. They want to run the business, but at the same time, this is having more value for them. Why? Because it creates and it gives money to them. Similarly, the patent's criteria should be novelty, inventive step, and non-obviousness. So these are the important things when you create a patent. At the same time, the patent related acts in India are India Patent Act 1970 and the Patent Rules of 1972 and the Amendment Act of 1999, 2002 and 2005. All these acts are applicable to safeguard your patent in India. Whereas when you are looking at the infringement of a patent and remedies, you are, whenever a monopoly right of a patentee is violated, his rights can be secured by instituting a suit of infringement. So a suit of infringement shall be instituted in any court not inferior to a district court having jurisdiction to try the suit. That means if the high court decision is taken only for his jurisdiction or a trial case, that means a defendant can make a counterclaim for revocation in a high court. So these are the important things which you have to keep in mind when you are doing some kind of a new patent inventions. At the same time, the suit is to be instituted for infringement of patent within 3 days from the date of infringement. If the terms of patents has expired and infringement has occurred during the term of patent, a suit can be instituted even after the expiry of the term also. That means who is entitled to sue? A patentee, exclusive license, if the license is registered, a compulsory license, or a institution or a licensee other than the two license can bring an action of so authorized by the owner of the patent. They only can instigate a infringement suits. At the same time, when the defenses has to be made in the patent, it means that two or more persons having jointly infringed the patents, they can be sued by the defendant. The onus is on the plaintiff to establish the infringement, and infringement if he is in as. That means the defenses has to be very specifically maybe set up very when the infringement happens and the license to use of this invention is made by some other person and existing of any ground for revocation. Let us discuss about the patent reliefs damages. That means the reliefs, that means an injunction. Everybody could have, the legal persons could have heard these words. An injunction is an order of court prohibiting someone from doing a specified act of undo something wrong, or injury, or injunction are two types, that is temporary and perpetual. So these damages, a successful plaintiff in a suit infringes entitled for a relief of compensation. But unfortunately or fortunately, having been there in the corporate side for so long, by the time you file a suit and by the time you get defended yourself, by the time the petition is heard and you have been given the stay, the other side competitor will make use of your patent or copyright or trademark in such a way that he will earn more profits. So in this, the formulas of infringement happens, the damages will be proportionately, and the sales, all these figures will be taken into consideration when certain amount of sales has been done and how much you need to pay the amount back to the infringer. So these are all the important things which you have to keep in mind when an invention happen, and at the same time that the person who infringes the patent also is also suable. I am telling you the few important cases. Hoffman Law Roche versus Cipla Limited. These are all the Indian companies. Novartis versus Union of India. Bayer Corporation versus Union of India. Bajaj Auto Limited versus TVS Motor Company. Just think of, it is not a scientific, it is not a cool drink, it is not a XYZ. It is also a machinery which is made for the model and type of the part which you are used, spare part in an automotive industry also. So these are all very, very important things regarding to the patents. And let us discuss about the copyright. The legal right granted in an author or a composer or a playwright, publisher or a distributor to exclusive publication and production, sale or distribution of a literary, musical, dramatic and artistic works comes under copyrights. Just think of, or a copyright is an author or a composer or a playwright publisher. So somebody is copying and doing the infringement, taking the writings of certain author and putting into some other person's magazine or some other things. Unfortunately, these copyrights are open to the exposure, and this particular thing, because it goes to the entire world, and this catching this particular thing in the infringement, we will discuss for that. And to protect the copyrights, there are certain acts are also there in India: Copyright Act of 1957, WIPO 1996, and all these acts, section 57 of the Copyright Act and the infringement under section 652 of the Copyright Act, all these things are law relating to the copyright. At the same time, when some, yes, the action can be called for infringement without consent or also license. To reproduce the work in any form of a material, just now we have been discussed. The issue of copies of the work of public not being copies already in the circulation. All these things can be an action to be called as a infringement. The import of one copy of any work for the private or a documentic use of this importer shall not result to infringement of a copyright. So it is compulsory that the copyright, whatever I prepared, need to get registered properly. If that particular publication is not happened, I have not registered, then it will not fall under the infringement. Certain cases I would like to share with you: Eastern Book versus DB Modak. At the same time, the Chancellor Matters versus and Scholars of the University of Oxford versus Rameshwari Photocopy Services. These are all the important cases of copyright infringement. At the same time, JN Bagga versus All India Reporters, making of an infringement work for sale of an offense. That means advertisement of an infringement book for a sale, display, or offer of a sale. When a person distributes any infringement copies of the work earlier for the purpose of trade, then he will be infringed. That means a copyright. Just think of how value is a book when his author prepares a fresh copyrights on that. Let us now discuss about the trademarks. Trademarks means any mark used by an organization to uniquely identified. That means a trademark, for example, if you take a trademark of a Canon, if you take trademark of a Xerox, you have the resemblance of Canon background with color also. That means the Canon resemblance, when you come out of the market, when it is somebody is displaying it, that means the color also have the back shade. That means that is how the trademark has been prepared. The design, and sometimes when you do a work in a computer, you may be finding different formats, italic or various formats you may be finding. So these formats also, when they prepare and register for the trademarks, all these things comes under the registration part of it. That means somebody is doing the trademark registration, all these things like a label, symbol, name, signature, numeral, everything will have a value. For example, the signature of Abraham Lincoln, it has some value. That the style of Abraham Lincoln signature, when he has made, that has a value in the world. That means the style and with the various curves in his signature also counts there. That is also can be made as a trademark. All these things will come under the trademark one, and a combination or a slogan, base or a punch, timeline, which is used for the describe of any product, also can be a trademark. And certain rules, like certain laws which are applicable, are Trademark Act, trademark under the TRIPS agreement, trademarks under Merchandising Marks Act. All these things will fall under the Trademarks Act. We have been discussing about the patents, we have been discussing about the copyrights, we have been discussing about the trademarks. Now very, very important is the trade secret, the confidential information. Not so popular in IP, drawing attention recently all over the world, is also a trade secret. For example, when somebody does a business, the process of doing that particular business in certain model can also be patented. If a software can be patented with various inside technical formalities, even the design of an SOP, a design of a marketing procedure can also be patented. This was not there earlier in India. Now it has been elaborately used in the worldwide, and Indian people also now were able to look at this so that they can also secure all their information intellectual property rights. That means a set of activities, ideas, or information not in public knowledge, which is unique and
Again, some technical issues has been occurring. Sir will join us soon. Thank you for your patience. Sir will be joining us in a couple of minutes. Kindly have your patience. Thank you.
Good evening, sir.
Yeah.
Sir, we have our first question from Vandana. Sir, she is asking that what is the difference between passing off and infringement in trademarks?
Passing of the
She is asking the difference between passing off and infringement in trademark. Because under trademark, there is a concept of passing off. So you want to understand the difference between passing off and infringement.
see, an infringement will cause due to the certain product or certain trademark which is having a human value, where in the trademark it creates a different sign. Like for example, the same trademark can be used in a different mode, and whereas in the passing mark is unnecessary usage in the various classifications. So this particular thing is the difference between a trademark and a passing off.
Okay, sir. Sir, we have a question from Jayant. He's asking, what are the necessary steps that one must take to go through to become a successful IPR lawyer?
One thing is that he should understand what is the basics of a copyright, trademarks, and designs. Yes, I agree with them that he need to understand the nitty-gritties and what is the laws applicable to them. Once he understands the laws related to that, and he need to also diagnose and understand with search. If you go for a search in a computer, in a Google or anything, patent search, trademark search, if he gets an experience of what will be the various forms and what will be the differences. For example, if somebody comes to me for a search of a patent or a trademark or something, when I do the search in that, because various government organizations also support to us, when we do the search, then we will be learning little bit about what is a trademark, what is a patent, how it is applicable in the world. So first let him understand the laws. Second step is that first let him learn the search part of it, and once he learns the search part of it, he will be able to learn the ambit of what is IPR and how to get into the practice.
Okay, sir. Sir, we have another question from Harshit. He's asking, what is the difference between industrial property and intellectual property?
See, industrial property is also part of the intellectual property, whereas industrial property forms a part of the intellectual property. Like certain categories, maybe the industrial property can be a trademark or a patent or a copyright. But this also forms under certain categories. Like earlier I was discussing about the secrets, Trade Secret Act. All these things where it will form a part of the IPR only. There will be not much more industrial property differentiation, but it will also fall under the ambit of IPR. But it relates to the formation where they are looking into.
Okay, sir. Thank you. Sir, we have another question from Priyanka. She is asking, if someone invented a new thing by using some existing things, can they come under intellectual property?
I will tell one thing, what is happening in the business also currently. If someone uses, it's okay, but somebody is making with a small difference. That is why I was telling, if you go for a patent search or a trademark search, if the formation, whatever they are forming in the new formation with a small difference, they are also getting registered. Then it will automatically will fall into a patent. It will fall under IPR only, because he's also getting registered with a small difference. Unless and until the infringement, whatever they are saying, it is coinciding with our IPR product. If somebody do not contest on that, with a small difference also we are getting it registered, because they are getting revenues. But the big players in that are also trying to bring out that particular new formations also purchased by them. Why? Because they do not want any competition in that. Yes, if the patent authority or the trademark authority or the copyright authority is going to accept that, then it is also part of the IPR only.
Okay, sir. Sir, there is another question from Jan. He's asking that, is there necessary for any certification or any programs that one should complete to become an IPR lawyer?
I see it all becomes, now the world has been changed. It has changed from different modes. It is not the law student or science student or engineering student. Everybody can do an IPR. Sitting at home, they can do the practice of IPR. There is no such qualification. But yes, he needs an experience. There is a patent examination is there, agent he can become, and if he is qualified to that. So there are certain qualifications are there. He should be a science graduate. He should be a law graduate. So certain people, certain categories need to undergo the examination part of it, but certain categories not required to go the examination part of it. So it all depends on the interest in which area he wants to work. Patent attorney, people say that. Yes, if somebody want to practice in the patent itself, then he'll become a patent authority. And somebody becomes only a trademark attorney. Generally, it is an ambit of IPR attorney. Like ADR, arbitration, mediation, and conciliation. So people have now can choose different kind of a corporate laws and get practice and learn the entire thing, the laws in that, and also get practice, work with as an internship with some person who is doing this particular work. Go and learn the IPR related if you want to learn, and then get the initial practice on that. Then you can do the work from your home also.
Okay, sir. We have one question from Anjali. She is asking that if anyone want to register anyone's scientific project, then how can he be done through IPR?
See,
a project which are best. Yes, sir. Yes, sir.
Yeah, like I was telling you earlier, the process itself, the copyright process itself. For example, a business model. A business model nobody was using earlier, but we are able to use it. The scientific method, how we are using, can be also registered under the copyrights. This is part of the IPR also. There can be a software solution where you have invented a new software, but it cannot be used by some other, but it will be registered under patent. So all these things have multiple interfaces where to get registered, and what exactly is that?
Okay, sir. Sir, one last question we have there. What is the difference between database rights and copyrights?
See, database rights are different, which falls under the difference. Like, for example, the multiple areas of the laws are there. Can you repeat the questions again?
Yes, sir. So difference between database and rights and copyrights.
See, copyrights is the formulation which they have an SOP or they have a model which they have get it registered. Other than this will form into a database, but database will form into certain categories. Why? Because database is, for example, if it is server-based data, like for example, WhatsApp. You have WhatsApp, you have Telegraph, you have different kinds of things which can be licensed, which the people also, the owners will not get allowed you to get into that. So that falls under the database. But whereas if it is a design based, which is a particular formation or a model based, I'm sorry to say the design in this word, but model based one, which will form under the copyrights.
Okay, sir. One question we have is, beside access to medicines, are there other intellectual property issues that implicate the protection of human rights?
It all depends on the country to country. You may be knowing India allows certain things to get experimented, or research labs can be put in place. If you go to Germany, if you go to the US, if you go, there are certain categories which are allowed within the country law frame. So yes, if it is the law within that particular different country, if law frame is allowed, then the company will come into that country and do that particular research based in that. So it all depends on the option where to work and what to get it out of that, including the medicines also.
Okay, sir. Sir, one question
Thank
from
you,
my
sir.
side also. Just a second. Sir, just
Last question, sir.
yeah. Okay. Sir,
Yeah, this will be the.
sir, can you suggest some, because many of our budding lawyers, can you suggest how to become the best book of IPR or something, that how to become a good lawyer and something, because we are all are budding lawyers. So your guidance, sir, on this.
I will tell you one small suggestion to you. My son is also a budding lawyer who is in the final year law. When I become a lawyer, I have become a lawyer, and then I have started learning different areas of the subjects like merger acquisitions, IPR, ADR, and various employment laws. But nowadays, the correspondence courses have already started. Without having the knowledge, like for example, understanding the basics of any of these particular subjects, very specifically IPR, there is a diploma from JNLU, correspondence course, web-based program. It's a diploma. My son has already done that particular diploma. Similar kinds of diplomas are available during your courses of law study. Earlier, it was not there. I had to struggle, get my law degree going for every day for 3 years and then do it. My son has already done the 5 years course and he has done 3 diplomas. So people, friends, looking, when you are coming out of a law graduation, you should have your option. Like for example, 5 fingers. You should have 5 fingers. Out of that, which finger you want to choose and getting into your life, for the practice side or for the whatever you want, you are interested in your subject. So learn, Google everything. All the courses are available. Without doing any course, don't getting into any internship. Once you do the course, get through the internship and learn best out of it, and then you will be the most dynamic person and you will be learning a lot. But without doing any course, don't do any experimental basis. Don't learn some subject which is new to you. But yes, after law, if you want to do certain things, you also need to get the practice. You also need to learn through the courses also, which I have myself has done the same.
Okay, sir.
Okay,
Thanks a lot.
Thank you, sir.
Thank you. Thank you
That
very
is
much.
a request. That is a request if you wrap up within 5 minutes, and we will end this session with a thank you note.
Yeah.
Thank you, sir.
Thank you.
Sir, you can wrap up. Sir, am I audible, sir?
Yes, yes.
You can continue with your PowerPoint presentation, sir.
Yeah. See, I've been discussing about the last slide only. That is the TRIPS agreement, which is prohibits the compulsory license of a trademark. That means the registered trademark which is answered or determined. So this particular presentation also will be shared to you, and where you find that this particular falls under the latest agreement, which is falls under a TRIPS agreement. 2 more slides are there, which I think I will share with you. Now this is the last. Okay. Thank you very much, and we can wrap up.
Thank you, sir.
Thank you. This presentation will be shared with the organizers, and you can have.
Absolutely, sir. Okay, sir. Moving to the thank you session, I would like to take this opportunity to place on record our heartiest thanks to Mr. JLN MURTHY, sir, for sparing time from his busy schedule to grace the webinar on Introduction to Intellectual Property Rights with knowledge and information, and for the guidance sir has imparted to all of us. It is to announce that it is our first webinar of legal intelligence, and we have recorded over 200 attendees. I also extend my thanks to the whole team of legal intelligence for their enormous cooperation in the organization and conduct of this event. Thank you, sir, for being with us.
Thank you very much.
Thank
Wish
you,
you all
sir.
the best. Wish you all the best.
Thank you, sir.
Everyone.
Thank you, sir. Thank you.